Welcome to Spotlight Television. I'm Damon Roberts. How can you protect your assets in such a complicated world? Well, between creditors, predators, and taxes, today's assets are at risk from more than just lawsuits. That's why it's important to protect your wealth. Joining me today are attorneys Howard Rosen and Patricia Donlevy Rosen. They are leaders in the field of asset protection. They serve clients across the United States and abroad, and they have extensive experience with offshore asset protection planning and related tax issues. And they are considered authorities on these subjects among their peers. Regarded as pioneers in the integration of complex protective trusts, over the last 40 years, they have authored a number of books, including Asset Protection, a Guide for Professionals, along with research materials and numerous publications that have been utilized by planning professionals and investors around the globe. Please welcome to Spotlight Television, Howard and Patricia Rosen. Guys, welcome to the show.
Thank you, Damon.
Thank you, Damon.
Well, it's great to have you. Howard, how would you define asset protection planning, and what makes your company in the space different from others?
We define asset protection planning as the arrangement of a client's financial affairs in such a way as to place their assets beyond the reach of future potential creditors, while at the same time the client continues to enjoy and benefit from their assets. We differ from other asset protection planners in many ways. Number one, we've been doing it longer than anyone else. We've had extensive experience, including actual litigation in the offshore jurisdiction where we established the trusts. We're available to our clients around the clock. They don't deal with associates, they deal with Patricia or me.
Do you have an opinion on why we live in such a litigious society right now? Why people, especially wealthy people, face so many lawsuits? Do you have an opinion on that?
We feel that that's a way that some people make money, okay? In our litigation system, lawyers can take cases on a contingency fee basis. It used to be the case that in other countries that wasn't allowed, although they've been infected by our system and it's starting to occur in other countries as well. But when a lawyer can take a case on a contingency fee basis, it really costs the client nothing to take a shot at suing someone, in effect.
Right, right. So they look at it as just that, taking a shot. And
It's a roll of the dice.
Roll of the dice.
Yeah.
So Howard, let's talk about your typical client. Who is that typical client who's coming to you?
Typical client nowadays is a business person, an entrepreneur, someone who's sold a business. When I give talks on this subject, I always emphasize that when a business is sold, the seller, who usually would be our client, should protect the proceeds of the sale immediately, because almost always a year later, the buyer has run the business into the ground and wants some of that money back. But really, anybody with any wealth in our society has an invisible target on their back for a litigator.
Not only has wealth, but who has great earning potential or inheritance potential should set this up. So what they accumulate over time can be protected before there's a problem.
Is there kind of a floor of assets and wealth that someone has to have to work with you, or who qualifies?
We're always asked that question, and the answer is it's like beauty is in the eye of the beholder. We have to give an answer, so I say that a person should have at least $1 million liquid, cash and publicly traded securities outside of IRAs, outside of qualified retirement plans, just sitting in a brokerage or a bank account. Okay, having said that, we'll accept a client if they're willing to pay our fee. We've had people with half that much say, where can I sign up? People with 10 times that much say, no, it's too expensive. So it's really, $1 million is what I say is when I'm asked that question.
On the other hand, if you're a young professional who's going to making a good high income, a plastic surgeon, you might want to start this nest egg going so that as you're earning, you can use it as your savings account and know that whatever you put in there is protected.
Right. Can be added to, of course, as time goes on.
So Patricia, let's talk about real estate a little bit. Obviously, owning property is the dream of everybody who lives in the country, to own a house. But obviously, owning property comes with a lot of risk. One of the biggest lawsuits, obviously, is real estate, people going after your home. In your opinion, is there a tool, or what's the strongest legal tool for protecting real estate from creditors today?
Well, first of all, one needs an offshore asset protection trust as the base of any protection. And with real estate, we can't move it offshore to protect it unless you live in California and there's an earthquake and it falls into the ocean. So the only thing that we found that works is removing the value of the real estate. And we do that with a structure that we developed about 30-something years ago that has worked against the US government even, where we remove the value of property, and we do that by working with independent offshore lenders who will lend 95% of the client's available equity. So we find out what the property's worth, we get an appraisal, we subtract any mortgage that might be on the property, we see what's there sitting there for a creditor, we get the offshore lender involved, they make a loan of 95%. Those proceeds, though, must be put into the client's offshore asset protection trust. Just getting a mortgage on the property won't do it. If the client puts the money into their checking account, the creditor will be delighted that the money's a lot more accessible.
So, Patricia, let me ask you this then, given the answer you just said. Why, instead of using an offshore lender to get a mortgage or a lien on your property, why couldn't someone just have a family member or a friend put a lien on the property?
Okay, first of all, that we're assuming that's a real loan that the friend or relative makes. Oftentimes, they'll just put a mortgage on the property and there really isn't a true transfer of proceeds. Substance over form, so a court would look at that and say that's not really a mortgage. And the question is, what did you do with the proceeds of that mortgage if you actually got money? Did you just stick it in your checking account? The creditor says, thank you. That's a lot easier to get a hold of. The offshore lender is independent, third party, and this is a real loan. There's a loan application, there's appraisals, there's due diligence. Generally with a family member, there's not. A lot of times people will give a family member a mortgage, and then what if you want the mortgage taken off and the family member says, no, pay me the money first. We're pretty much stuck. And besides a family member or friend, we've seen companies, there's especially a company out of the Midwest that we've had people come, they've got a mortgage, and it turns out they've just paid a fee to have somebody put a lien on their property that isn't even real. Ours are, what we do is a true loan made to the client, the proceeds of which are put safely in their offshore asset protection trust account, offshore, out of the reach of the lender. That's the whole idea, to get the value of the property offshore where no U.S. court can get to it.
Is there a learning curve? This is an interesting question because I think when people hear the word offshore, there's immediately some kind of stigmatism to like, oh, what are we doing? Is there a learning curve in what you guys do, and either one of you can take this answer first, to make people feel comfortable with the idea of moving things offshore and what the legality of that is and how comfortable they can be with that? Is there a learning curve with clients?
I don't know if you would call it a learning curve, but there's a comfort curve, if you will. And the way I address that for a client, because they do ask these questions, the way I address that is I say, how would you select a doctor if you had to have a complicated, life-threatening surgery? You would look for the one with the best credentials, that's regarded as such by his peers, et cetera. That's your first security level, okay? The second security level, and that would be us as far as a lawyer goes. The second security level is, have we, as the law firm, have we done our due diligence on these offshore companies that we do business with, the offshore trustee company, the offshore financial institutions, et cetera? And the answer is, of course, yes. We have traveled to the offshore jurisdiction where we set up the trust 20 times in the last more than 3 decades that we've been actually setting up trusts offshore. So before we ever set up the very first trust there, we went there and did our due diligence on them. We've traveled around the world and met with the financial institutions where the trust will set up its financial accounts. We've done our due diligence there, and we relate that information to the client, and that gives them the comfort that they need.
How do you assure people that some offshore trustee that they don't know doesn't steal or run away with their money someday?
Good question. Okay, we're asked this all the time. First of all, like I've said, we vetted the trustees in person. The Cook Islands trust companies are more highly regulated by that government than our trust companies are, because that business to that little country is 11% of its gross national product. Having said that, there's more. There's another party, another offshore company involved. First of all, the trustee is a company. They sign documents with 2 of their employees each time. There's another company involved called a trust protector company located in a different country. The trustee company needs to get the prior written approval of the trust protector company before any money can go out of the trust. They don't know each other. They're in 2 different countries. Both of them sign with 2 different employees. So that's a check and balance that's built into every trust that we do.
You ask about the learning curve, and I know when we first got into this business in the early 90s, I had my law school friends calling me saying, "Donlevy, you were such a straight arrow. Why are you doing this slimy stuff?" Right? You say offshore, people get, oh, they're hiding assets. What we do, we are not hiding anything. There's nothing hidden. Once this structure is in place, actually, if a client gets sued, we say, tell your litigator to bring this to the other side. They'll see this is rock solid. They're not going to get anything, even if they get a judgment. We don't hide assets. We don't try to avoid paying taxes. A client is given a huge document to give to their CPA, so they file all the necessary forms, and so there's nothing shady going on. And we also tell the clients that we have done this ourselves and have been sued, and how it's worked for us when we were sued unfairly.
Yeah. Now, Patricia, could you use this program to pay off a first lien?
The real estate program is not for paying off the first lien. If a client has a first lien, the offshore lender will accept a second lien, but the client must know they must pay off the first lien, otherwise there's no protection. The first lien holder gets first dibs.
So we talked a little bit about taxes. Taxes are obviously a huge deal. Howard, you're a certified public accountant, I believe. Yes. Let's talk about taxes a little bit. What are the tax ramifications of an offshore asset protection program?
Actually, they're quite simple. The trust is referred to in a non-technical parlance as tax neutral. Okay, that means it does not save any income tax for the client, and it does not cost any income tax for the client. It does involve some information reporting to the government. But as Patricia mentioned, we provide the client with a detailed tax compliance document for their CPA so they know how to do this properly. So it's really tax neutral. The only tax savings, if you will, is that the typical asset protection trust will include conventional estate tax savings provisions that would be in any domestic trust that a general estate planning attorney would include.
And so is there a primary method you use to implement this type of tax planning? Is there one specific that you use?
The core of the planning that we do is always going to be an offshore asset protection trust. Okay, and that trust will include, as I just mentioned, it will include the typical estate planning provisions, such as continuing trusts for a surviving spouse, continuing trusts for children and grandchildren, those types of provisions. But it's much more than that, in that it has numerous protective provisions in it.
And so just to be clear, I want to be clear with the audience too. You guys are not in the business, people who are coming to you have already decided what vehicle they're using to invest their money, whether it's a 401k or a Roth IRA, especially when it comes to taxes. You're not giving tax advice as far as, oh, your money should be out of a 401k and converted into a Roth because taxes are going to go up over the next 20 years and you don't want to. You're not doing that. You're just there solely to protect what they already have.
Correct.
And what they're going to get if they're still making money.
Right. So Patricia, let's talk about assets and let's talk about obviously legal risk. I spoke about it in my opening. We live in a very litigious society. If you've already been exposed to some kind of legal risk, is it too late at that point to look at protecting assets?
Let me give you a lawyerly answer. It depends. It depends on the facts. It depends on how you own your property, what state you are in, what kind of claim this has been that's against you, how big of a claim, what assets you have, and how they are titled. So we would say if someone has already had a the smell of a claim coming after, they should immediately talk to an asset protection attorney and find out what at this point they can do without getting into fraudulent transfer issues.
And when you say what state you're in, obviously there's states like Wyoming and others that make it a little harder to kind of pierce the corporate veil or thing. Is that what you're talking about?
No, well, no, I was thinking more of whether or not, if you're married, if you're in a state that has tenancy by the entirety or a community property state, or if you're single or married, how much. Like in Florida, we have a very large homestead protection, 100% of your homestead if it's under, a certain amount of space. Same with Texas, whereas other states have hardly any to nothing. And again, it depends on how it's titled. Do you have LLCs that hold the property and you are personally being sued? That's what I meant by it. It so much depends.
In a situation like that, where you're talking about an LLC or a business, the state they incorporated can make a difference.
No, not necessarily the state where they're incorporated. It's maybe where the assets are of the entity, right? Because even if you are incorporated in Wyoming, but you're doing business here in New York, with your assets here in New York, a litigator is going to be able to get the assets. That's why we move assets offshore, because if they're, and why we say this is so much better than a domestic asset protection trust, because domestic asset protection trust, the assets are here. When we set up the offshore trust, and when we do it, because we've seen it when attorneys haven't urged their client to get the assets offshore, anything that's here, a smart litigator will be able to get after.
That's the bottom line.
That's the bottom line.
Interesting, yeah. So let's say I'm actively I'm being sued, and I have a property that I want to sell. Can I sell that property if I'm actively being sued?
Well, let's say you've set up the real estate protection program with us before the lawsuit, and it's in the program. The answer is yes, because we have a way. I mean, you don't. You have to pay off the lender. We have an offshore lender you owe money to. So what you would do is have the closing, and at the closing, remember, 95% of the equity would be going to pay off that loan. That would mean at the end of the day, and I won't go into the step-by-step, that 95% of the equity would end up being in your offshore trust, offshore account, out of the reach of creditors, never in your hands, so they couldn't take it or it couldn't be considered a fraudulent transfer.
If someone wanted to open up an offshore trust to start to think about protecting assets, is there a best country to do it from?
We've researched many countries over the years, but the Cook Islands is the only country where we currently set up offshore trusts. Number one, the Cook Islands was the first country on this planet to enact focused asset protection legislation back in 1984. The Cook Islands is a Commonwealth country, a British English Commonwealth country, same as Australia, same as Canada, and they became independent. They used to be part of New Zealand, like Puerto Rico is part of the United States, but they became independent in 1965, and they needed a way to generate some revenue for their country. So in 1984, they enacted the first focused asset protection trust law. Since then, 30 or more other countries have jumped on that bandwagon, but the Cook Islands has a track record which includes having thrown the U.S. government out of court twice. Because they don't get any aid, financial aid from the United States, they have no treaty with the United States which would require them to enforce a judgment of a U.S. court, which they will not do. And they have the most experienced trustee companies that we've ever dealt with, and I've always been a trust lawyer. So, and we've been there, like I said, 20 times in the last more than 3 decades that we've been doing this over there.
So Patricia, let's talk about couples, let's talk about marriage, let's talk about taxes, let's talk about a couple things here. Can an asset protection offshore trust be used in lieu of, let's say, a prenuptial agreement?
Yes, or as a supplement to. We've had a number of, I wish more women would do this, but we've had a number of men come who are getting married. This is a prenup doesn't sound very romantic. I want to marry you, but sign this paper, you know? So a lot of fellows have come and they've set this up before they get married. And the thing is, whatever's in there, that's great, that's protected. But now, And prenups often are overruled by courts for one reason or the other. So yes, it is an alternative. It can be a supplement. Does it mean that you shouldn't? Because whatever you have in there, okay, that's protected. But let's say I'm a movie star making a lot of money. I've got the offshore trust, but here I am living in California, a community property state, and then I want to get divorced. Well, the court's going to take into account the fact that I have this offshore trust, because remember, it's not secret. And they may take that into account in deciding how much of your ongoing income made here in the United States you'll have to give to the ex-spouse. So yes, it can be in lieu of, it can be a supplement to, and it's certainly more romantic than telling your to-be, let's sign some papers.
So are you saying there that a court in California could say, oh, we're going to demand more from you now of your incoming because we know you have this trust that we can't touch?
Yes.
Is that what they're saying?
That's possible, yeah. We always look at the worst case scenario when we talk to clients.
And is that unique to a state like California?
No, any judge could say, well, like, show me what you have, and oh, so you have these assets. The judge might say, bring them back and give her half. Well, that's not going to happen the way Howard has drafted the trust. The trustee, let's say it's a woman who has an offshore trust. Okay, so the judge says to her, all right, bring back half those assets and give it to this guy. And she will do what the judge says, and the offshore trustee will know she's in a divorce proceeding and ask, are you doing this on free will? No, the judge has ordered me to. The trustee will say no, because the way Howard has drafted these trusts, if a client isn't asking of his or her own free will, for assets to come back for their benefit, but they're being forced, the trustee will not have the ability to do that. And then nothing can happen to her because she's doing what the court asked. And we found so far no court has asked a client to lie under oath, which is perjury, right? By sending an affidavit to the Cook Islands saying, I'm doing this of my own free will, even though the court's forcing me.
So I'm sure when you explain this to new clients must listen and have to ask, has this program withstood any challenges? That has to be part of what they want to know when listening to this. So has this program been challenged in court? Has it stood up? Tell me a little bit about that.
Well, here's the bottom line. Okay, when we set up one of these trusts, as far as liquid assets in the trust, that's cash and publicly traded securities, it's bulletproof. The reason is that no court in the United States has the ability to tell the Cook Islands trustee company what to do. The only way for a creditor to get assets from a trust is to bring their lawsuit in a court that has the power to tell the trustee what to do. The only one that has that power is the one in the Cook Islands. Or to bring their lawsuit in a court which has the power to seize the trust assets if they're here. And that, again, that's the Cook Islands court. So the only option for a creditor who wants to try and get at one of these trusts is to go to the Cook Islands, hire lawyers there, because they will not allow the lawyer in the U.S. who represented the creditor here to practice over there. So the creditor has to hire a lawyer in the Cook Islands. They won't take the case on a contingency fee basis, so the lawyer has to be paid up front in the Cook Islands. This is already getting daunting, not to mention the fact that the Cook Islands are near New Zealand, in the middle of the South Pacific, geographically difficult to get to. Then prove the case beyond a reasonable doubt. They require, if you remember O.J. Simpson, they couldn't prove that case beyond a reasonable doubt. That tells you how difficult a standard of proof that is. And that's a criminal standard, but in the Cook Islands, they use that requirement in these civil cases. That's their law. That's what they decided to do. So, yeah, so a creditor cannot do that. And as I said earlier, I believe that the Cook Islands has thrown the U.S. government out of court twice. We've had litigation there with our clients' trusts, never successfully for the creditor. For example, if I'm a doctor and I set up one of these trusts and somebody's suing me for medical malpractice, that would not be the issue in the Cook Islands, because the trust had nothing to do with the medical malpractice. The only question for the court there would be, was this a fraudulent transfer, a transfer intended to hinder, delay, or defeat the claim of a creditor? And their law, as I mentioned, requires proof of that beyond a reasonable doubt and a very short statute of limitations, 2 years at the maximum. So chances of getting there within 2 years are slim and none.
So guys, obviously you look around the world financially right now, at least here in the US, $34 trillion in debt, keeps going up by seemingly billions of dollars a day. People look at inflation. We've never seen 9.2% it topped out at. They see their purchasing power going away. When you think about wealthy people and they think about the future and they think about taxes probably having to go up, because how do we ever deal with $34 trillion in debt? Can an offshore account and international financial instruments, can they help to guard against any of this, against the devaluation of the currency, against their purchasing power being taken away? What can we do there?
Well, I can tell you that the offshore trusts can invest in things that a U.S. person could not directly. You know, we here can invest in things the SEC has okayed. The offshore trust can invest in many instruments that aren't SEC approved, and
Which doesn't mean they're not good investments.
exactly. And the offshore trust, besides in different currencies, can invest in different currencies. And what it does, often the trustee, the money manager of the trust account will talk to the client, because we do have clients who say, I want all my money in gold. I want all my money in platinum. I want all my money in Swiss. I forgot what Swiss is called. Swiss francs, or Swiss and Liechtenstein. So the answer is yes. A client has options with the use of the offshore asset protection trust that they might not have here. Some that they might, but many that they wouldn't have as a U.S. person trying to invest.
So obviously there's a big audience watching you guys today, listening to this. I'm sure there's a lot of people hearing this for the first time. We talked a little bit about the stigma of hearing the word offshore. But if someone's interested in picking someone and thinks, man, this might be good for my situation, what are they looking for? What is the things that you caution against people looking for? And what are the positives? What should people be looking for in picking someone to set this kind of scenario up for them?
2 words: experience and qualifications, and it must be an attorney, okay? On our website, we have a document that's 14 questions you should ask of any attorney you're considering hiring as an asset protection attorney. Those questions are crucial to look at.
Anyone hiring an attorney should be very comfortable with that attorney and get a feeling that they trust him or her, besides answering the questions that Howard mentioned, because it's really important that the client tell the attorney the truth and get the facts correct, because if you go even to a decent asset protection attorney and lie about the assets that you have in your situation, you may spend the money and then not get the protection if they don't have the facts.
And as somebody who's listening to this for the first time and thinking about it, there's not a lot for the client to have to worry about. They have to move things from one account to another, or people start thinking, oh, geez, I don't want to have to sell that and then put it. Talk about that process. Is there a process of assets that need to change to work with you guys, or can everything kind of stay where it is and it just kind of, talk a little bit about that?
It depends on what the assets are. If it's cash, it's easy, but the trust, the offshore trust, will have offshore accounts, so it can't remain at Schwab, it can't remain at Fidelity, it has to be moved offshore. Having said that, if the securities in the account are General Electric, Apple, those can usually be moved without being sold. If the funds in the account are in a proprietary mutual fund of Fidelity or Schwab, that will have to be sold.
All right, guys, let's do the most important thing we can do. This has been a great conversation. Howard, if somebody is watching this and thinks, man, this is interesting, I really need to do more research, I want to look into it, I want to contact them, tell everybody how they can contact you, give them the website, give them the phone number. How do they get in touch?
The website is ProtectYou, all spelled out, protectyou.com. The phone number is 305-447-0061. Call the office. Our assistant, Angela, will set up a time for us to speak. We do not charge for an initial consultation.
once somebody is our client, we don't charge to speak with them. We really want a client to keep the integrity of his or her structure. So we ask that before they do anything, buy anything, selling, they give us a call, run it by us so we can make sure they're doing the right thing for their protection.
Well, Howard and Patricia Rosen, I want to thank you for being here on Spotlight Television. Absolutely fascinating conversation, and we hope people will reach out to you, and thank you very much.
Thank you for having us.
Thank you, Damon.
And I want to thank you for watching us, and until next time, we'll see you right back here on another edition of Spotlight Television.